Let's welcome in our guest, attorney at law Danny Staggers in downtown Martinsburg. Danny, good morning. Welcome back.
Good morning, Rob. Good to be here.
Wonderful to have you.
Sometimes I get worried when I have to come here.
Because?
Because of questions you may fire at me, or Bill, or Matt. So I have to be
We're
really
gentle.
nervous.
We're gentle.
You are.
Yeah.
But you got to worry about it. You never know when it's coming.
I say this every time you're on the program, Danny, and oftentimes when I mention you as a sponsor here on the program, that if you're looking for a birthday cake, a celebration cake, a wedding cake of any sort, call Danny. He can't bake it for you, but he knows who can.
Oh, yeah.
I understand now we've gone from cake to cinnamon buns, which are even more attractive.
Cinnamon buns was your nickname back when you were in the Navy for a while.
I've done many a times. Here comes old cinnamon bun.
Oh, cinnamon bun Stubblefield is what they used to call you. Yeah.
Only behind my back, though, right?
Danny, how do you get in touch with this incredible cake baker?
Oh, you can call me. I can give you her name. But
Yeah.
that might be, she might not like that. Her name is Julie Landis. She works out of the Hampshire County High School. She's a home ec teacher. She's wonderful. She's wonderful. She was the bakery chef, the pastry chef at Nemacolin. But fortunately or unfortunately, fortunately for me, she had a boyfriend in Romney, West Virginia. So she left Nemacolin, came back to Romney, and she married him. She had 4 children. She works, like I said, at the home ec department in Hampshire High School.
Those have got to be the best fed high school kids in the history of high school.
Oh, yes.
I'm just passing along that knowledge, so there should be some
hope
pretty
so.
good pastry chefs coming out of there, too.
Very good.
Yeah.
And very nice person, too.
And a very reasonable rate, too, for the
Oh, my
cake
God.
that she
It's
bakes.
great rate from her.
We're talking wills today,
Yes.
Danny. So can you really literally drop a will on the back of a napkin and it's hold up legally in court?
Yeah, I mean, you know, the theory of the law is to make sure you do have a will. I mean, if there's some documentation of it, the court's pretty much going to honor it. I mean, it could be notes scribbled on a piece of paper.
With or without being notarized.
Well, you can handwrite your will. It's called a holographic will.
Yeah.
If you write it on a piece of paper, date it, and sign it, it's a good will.
What about if there is another will pre-existing that is duly notarized and more proper? Which of the two takes precedence?
And Bill, that's a great question because the court's going to look at the later document that you've prepared because they're going to say, oh, he or her has changed their mind. So they're looking at that later will. So they try to uphold the intent of the person. You know. So, but the point I wanted to start out with is. And I'll call on Bill here in a minute on something, a question.
Well, he'll interrupt before you call on him.
is people need a will. I mean, you know, because your wishes need to be honored. And the frustrating thing about it is many people don't do a will.
Right.
After 30 days, if there's no one that has been appointed as the executor or the administrator, anybody can go in and qualify as your administrator. Then, as you know, Bill, they get a document saying you've been appointed. It's like a power of attorney. Now they can go in to look at your financial affairs. They can basically, I think, can even enter your house to do an appraisement. You know, that would be their theory. So, you know, wills are very important.
No, but if I'm married and I die first, doesn't everything automatically go to my spouse?
It does.
Even if I don't have a will?
It does, but that 30-day period goes by, somebody else can go in and qualify. Let me give you an example of a case we had in Mineral County. Husband and wife passed. Now, she had a will, husband grieves. He doesn't get in the 30-day period.
Get in where? Where do you?
Into the county clerk's office, to the probate office. Many counties, it's all run through the county clerk's office.
So that's something that has to happen. A spouse dies, the surviving spouse has to get to the county clerk's office within 30 days with the will?
They should. And the law says you should, and says if you don't, you can be guilty of a misdemeanor. I know. Yeah. I don't think it's ever been enforced, but it is in the code.
Wow.
And so in this particular case, I know when my dad died, it took me like 2 months. You know, you're grieving, you just don't want to do it. And it was pretty much similar in this case in Mineral County. The husband had the will. He just, you know, he's grieving, trying to take care of other things that you have to do after a spouse passes. And the stepson, the wife's son by previous marriage, runs into the county clerk's office. He gets appointed as the administrator of the estate. Guess what he starts doing? Going to the banks, taking the money out of the bank account, and going to other places and getting money, because this lady lived in Mineral County, but she had some assets in Cumberland, Maryland, which is right across the river. And the husband came to me and I said, "Oh, this is going to put us in a real bind because you didn't bring the will in." We had to go undo all that. And the son had absconded with this money, and he didn't want to give it back. We had to go through the magistrate court, in Mineral County, and then we had to go to the Register of Wills in Cumberland, Maryland. So the point being is, with or without a will, you should have a will. I mean, just so you can outline what you want to do with your assets after you pass.
If you do not have a will, is the court responsible of trying to determine intent of what you'd want to do? And let me go ahead. There's another part to my question.
Sure.
And this is something very recently happened to in my family. A young fellow a nephew who was had quite a few assets, but he died suddenly without will. We surmise that everything is his intent, no will, but his intent might be tied up on his telephone. But how do you get access to one's telephone?
Well, and 2 points in that bill is number one, the West Virginia legislature has already predetermined your intent. There's a layer that it goes through. Okay. I think you were saying about technically you're married. This is the first wife. It's all going to that wife. Okay. But if there's something else out there that you can show, then it's going to get into litigation. And again, that's why a will outline how you want this to go. Yeah. And the other thing about a will is, if you don't have a will and the executor appointed, now you got to be bonded. And that's based upon personal property, and that can be expensive and time delayed trying to get up there and get, to the insurance office to get that done. And the other thing, and this is what I was going to throw at you, is a prominent person. I think I'm correct on this, but I don't think Abraham Lincoln had a will. I really don't think that he had a will.
Was it common in those days to have wills?
Actually, I don't know. I mean, wills go back to ancient times. This has been in play for, ancient Egypt and, Greece. But for the longest time, too, Bill, if you think about it, the first son was always the prevailing person to receive, the assets. That's why with the will, you can overcome that. I was the sixth in a family of six. So I was not going to be in that line of getting anything.
You would have gone into the church. And that's generally the most junior one out of the family went into the church.
Yeah. That's right. The other thing I wanted to throw out too with the wills, because you can provide for people. For example, your parents are elderly. You want to make sure they get good care. You can do what is called a special needs trust in the will to make sure that family member gets treatment and assistance without losing any public benefits that may be out there. And that's important to know. Or you got a spendthrift child that's out there spending. So we can, I know. Matt, it's kind of...
Matt's laughing over there.
Yeah.
You got somebody in mind, Matt?
No, not at all. Not at all.
You think about it, and you've got a child, and you're going to leave them money. I don't know about you all, but if I'd have gotten a bunch of money at age 18, it would have been going. Vacations, car, something like that. So if somebody comes in with children under the age of 18, we're recommending you do a trust for that child. And usually I have an inducement in the will, get your post-secondary education, because that is really important. It doesn't have to be college. I mean, in today's world, it could be all kind of things, but get your post-secondary education. If you do that, money will come out to the child at age 23. If you don't, then it doesn't come out to, say, 27, 30, for that child to get a little more maturity.
If wills are accepted by the court, then how are they contested?
Well,
because people contest wills all the time.
They do. And then the question is, was there undue influence? I didn't do it, but when last 10 years of my mom's life, I was there to take care of her. So my other siblings could have said, you were using undue influence to get something. Now, she was very fair in distributing everything to the other family members, but you can see, I'm telling you, and Bill can verify this, you want to see greed? Boy, it comes out when mom or dad passes.
Exactly right.
And it's sad.
The county commission sees this all the time,
Yes.
and the worst side of a family
Yes.
emerges in these contested
Yes.
decisions.
Yeah, and it's so sad, because mom and dad never anticipated that. And that's another reason to have a will to outline what you want, to.
Now, I'm sorry, Matt.
Go.
I was just going to ask, how vague or how detailed do I need to make my will, depending on what I have?
Well, and again, you don't want to be too complicated. I think you can outline it very generally and make the point. And again, the court's going to look at it trying to uphold the intent of that person. So I think you could do a simple will. I try to keep things simple. I don't try to, complicate. I'm not a big advocate of trust, but just like I've said, there's occasions where you want to have a trust, to take care of people. The other thing you got to think about too, and I think if I'm correct, is the exemption amount for tax, for estate tax. I think it's still about $25 million. I don't think that's been changed. But you get close to that. Now we got to do a trust to try to protect the assets for the surviving spouse. So
I'm leaving $25 million to somebody. They're
oh,
now
am I
it
on that
becomes-
list, Matt?
No. I'm just the way you brought that up. I thought you were saying I have that kind of money. I'm like, okay, $25 million. I don't think we'll have to worry about that.
Yeah. And the other thing, and I'm hitting a lot of points real quick.